Good morning, everyone. My name is John Cornwell, and I'm the Marketing Director here at Plunkett Cooney, helping out in today's program. So we're happy to have you here. We have a number of people joining us today. It's my pleasure to serve as coordinator. So I'm going to handle the tech issues and some of the behind-the-scenes items today. So we really are happy you're joining us for the program, which we see as focusing on providing you with all the info that you need to ensure policy and regulatory compliance by your employees. And we know that many of them continue to work remotely, and I know we're going to cover a lot of ground today. We're talking about recent court rulings in particular. It's the whole opinions matter concept that we're covering today. And so we're happy to have with us two of our employment law practice group attorneys, Laura Dinan from our Petoskey, Michigan office, and John Gillum from our Bloomfield Hills office here in Southeast Michigan. Before we get started in earnest, I do want to point out a few things, give you a little background about our firm, and then we'll get right into it. So for those of you who don't know, Plunkett Cooney is based in Southeast Michigan and is one of the Midwest's oldest and largest law firms with approximately 140 attorneys. We have offices in 7 Michigan cities, as well as in Chicago, Indianapolis, and Columbus, Ohio. Our employment group is comprised of approximately 20 attorneys who work primarily in the area of traditional labor law, human resources consulting, investigations, and employment litigation. Now, today's webinar has been approved for 1.25 general recertification credit hours through the HR Certification Institute and 1.25 professional development credits through SHRM. Following today's program, a certificate of completion will be emailed to each of you reflecting this credit. If you don't need the credit, simply disregard the certificate. So with that, I would like to introduce our speakers. As I mentioned, Laura Dinan is here with us along with John Gillum. Laura has over 30 years of experience advising employers of all types of workplaces, in all types of workplace-related issues, and she's built a successful practice representing public and private sector employers of all sizes throughout northern Michigan. Laura's expertise includes consulting on employment law issues, administrative hearings, traditional labor matters, and litigation. She's a current board member and past president and past secretary of the board of directors of the Northern Michigan Society of Human Resource Directors. John Gillum has more than 10 years of litigation experience and focuses his practice on representing and advising employers across various industries. His litigation expertise includes a range of matters from discrimination and harassment to wrongful termination and incidents of workplace violence. He also advises his clients on a host of employment issues, including corporate policies and procedures, contract negotiations, and consultation on human resource actions. So now just a couple of quick housekeeping matters for those of you who can take a moment and look at your widget on your, I call it the widget, I guess it's a dashboard these days, but for the Q&A portion of our program, we're going to use the questions, the Q&A widget on your dashboard. How about that? We'll go with that. The Q&A widget on your dashboard. So if you could take a moment now to find that, you could start to type in questions throughout the program. But we'll probably take those questions at the end of the program. That's how we try to wrap things up so we get through what is today a really jam-packed agenda. So take a look for that widget. And again, I invite you to type in your questions as we go. The caveat that I always add is just make sure that when you ask your question, don't get into too many specifics about your actual workplace so that we don't disclose any workplaces or individuals who may be involved in specific situations. Just kind of keep it generic, if you will. Finally, I want to mention that today's session is being recorded, and that recording will be available on the event page of Plunkett Cooney's website, which is located at plunkettcooney.com. So feel free to share the link or direct your colleagues to that page after, probably a little later today. Tomorrow morning at the latest, we'll have that audio posted. So if you want to listen again or share that link, we encourage you to do so. So with all of that, I would like to just thank you again for attending today's webinar, and let's get things started. Laura, I think you are leading off today's presentation, so please take it away.
Thanks, John. as John said, we're really happy to have you with us today. We realized when we put this together that we haven't done a case law update in a while, and I don't know if it's due to COVID or what, but the cases have just been pouring out at every level. So hopefully you will find this informative. John, next slide, please. Today we're going to cover cases out of the U.S. Supreme Court. We're going to talk about Sixth Circuit decisions. We're going to talk about Michigan decisions and a little bit about what the legislature's doing, although there's not that much going on at that level. We'll also touch on what to watch for in employment law trends, and then we'll take your questions. So the Supreme Court continues to consider a lot of critical labor and employment law issues. The 2021 to 2022 term is wrapped or coming to a close, but there were several significant cases that we wanted to bring to your attention. The first one is Viking River Cruises versus Marino, which came down in June of 2022. And it dealt with arbitration in California, and the ruling was 8-1, with the holding that the Federal Arbitration Act allows employers to enforce arbitration agreements regarding individual claims asserted under the California Private Attorney General Act. Although this is a California case, the implication is much broader. What this means is that it could be much harder for plaintiffs to bring class action arbitration suits. It's expensive for employers to defend class actions, and we've seen there's a real push among the plaintiffs bar to bring class actions whenever they can because they save money by doing so, and it's much more expensive for employers. So this is an employer-friendly case potentially. Again, it was specific to California, but it's guidance for other states. The next significant case I'm pretty sure everybody has heard about is Dobbs versus Jackson Women's Health Organization. This is the case that overturned Roe versus Wade and Planned Parenthood versus Casey. It held there was no right to abortion in the U.S. Constitution, and thus returned the authority to regulate abortion to the individual states. We've already seen, if you even listen to the news in passing, many states are actively legislating on these issues right now. It was like opening up the starting gates at a horse race when this decision came down. But the implications for employers are vast, and I think we're going to still be discovering these as time goes on. But the ones that are being talked about right now are whether you need to change your benefit programs with respect to reproductive health care coverage, emotional responses and protests within your workplace or among your employees, freedom of speech issues, just disharmony in the workplace. And with respect to employer policies, a lot of employers are considering adding benefits, such as paying for travel if you're in a state that's banning abortion. There's all sorts of potential costs and policy considerations out there. And the EEOC position on this is that employers may not discriminate against employees on the basis of an employee's decision to have an abortion, that it's protected under Title VII. I think many of you may have heard that yesterday in Michigan, the Attorney General had filed suit. Someone had filed suit against the Attorney General seeking to prevent the Attorney General's office from enforcing Michigan's abortion ban that dates back to 1931. And Judge Gleicher in the Court of Claims had previously granted a temporary injunction saying that the ban could not be enforced. And yesterday she entered a permanent injunction. So the state of the law in Michigan currently is there is no ban on abortions. I'd be shocked if it wasn't appealed, but as of yesterday, a permanent injunction was entered. The Attorney General's office is not allowed to enforce the ban. Next slide, John. So these, the next two cases are COVID-related regulations. So National Federation of Independent Businesses versus the Department of Labor came down in January, and many of you, I'm sure, were aware that OSHA put a rule out there requiring large employers of 100 or more to have a vaccination or testing requirement for all employees. The Supreme Court held 6-3 that the federal government lacked the power to impose this kind of sweeping requirement on workplaces throughout the country, although the decision was generally supportive of state pandemic initiatives. So if the state was doing it, it was okay, but the opinion of the Supreme Court was that the feds could not impose these sweeping requirements on workplaces. And then in the next case, which came down the exact same day on a similar issue, Biden versus Missouri, in a 5-4 opinion. Remember, the other one was 6-3, so somebody moved on this one, and I can't remember off the top of my head, sorry. This involved a similar rule, but it came from the Health and Human Services Secretary, and it was allowed to stay in place. So the Supreme Court allowed this different policy to remain in place, and this one required COVID-19 vaccinations for most healthcare workers at facilities that receive Medicaid and Medicare funds. And the rationale was that Health and Human Services has a responsibility to protect the safety of patients and control the spread of infectious diseases. So it was okay in the medical setting because that's what they do, but it was not okay in the general workforce because it was just too broad a power for the feds. In the next case, Kennedy versus Bremerton School District, again a 6-3 opinion, the Supreme Court reversed the Ninth Circuit. The conservative majority sided with a former high school football coach who was fired after leading post-game prayers on the 50-yard line. He had been told to stop praying at midfield after games. The school district had presented other options. The coach refused and continued to pray at this on the football field after games, and he invited students and parents and coaches to participate in the prayer with him. The court held that the coach's prayers at the public school event were protected by the Constitution's guarantee of free speech and religious exercise. They also held that it did not violate the prohibition on government endorsement of, that is an error, it's supposed to say religion, not litigation, sorry for that typo. The dissent focused on the majority decision ignoring the Establishment Clause, which prohibits state establishment of religion. And that was actually the issue that was up on appeal. The court ignored it and found a way to allow prayer at public school events under the Free Speech and Religious Exercise Clause. So kind of deviated from the issues that went up before it to find a way to put the whole holding they wanted out there. And with that, those are the significant Supreme Court cases that have come down this year that we think are have the potential to affect most employers. And John is going to take it from here on Sixth Circuit cases.
Thank you, Laura. Yeah, as Laura mentioned, the Sixth Circuit has started picking up its cases. There was like all other courts, there was a continued slowdown during the pandemic. Laura touched on the National Federation of Business versus Department of Labor case, but since then there have been some cases that we think have come out recently that may impact employers. Generally, the trend continues to be that the court is pro-employee, but there are some exceptions. So we'll take a look at a few of those cases. The first case we want to address came out last month. This is Rachel Post versus Trinity Health, Michigan. The general proposition of this case is that the Americans with Disabilities Act does not allow a plaintiff employee to pursue an interference claim against a non-employer. So the facts of this case involved a nurse anesthetist who worked for a hospital, but was subsequently transferred her employment to a physician group, whereby she continued to work for the same hospital, but was an employee of the physicians group. She suffered an accident and was unable to work, was attempting to come back, but due to her disabilities, she had a couple of issues. One, when she would be able to return to work, but secondly, when she would be able to be credentialed. And an issue that arose was that, to retain her credentialing, she had to demonstrate that she was able to perform the functions of her position. However, the university physicians group chair would not credential her while she was on her leave. Thereby, during her leave, she actually ended up losing her credentials and was subsequently let go of her position. She pursued an action against both the university group and the hospital, claiming that they interfered with her right to a reasonable accommodation under the ADA, and additionally included a claim that the hospital group conspired with the university to deprive her of these rights. And the court dispelled of the civil conspiracy claim based on some longstanding precedent. But what the court's opinion really addresses is whether, under the circumstances of her employment as a employee of a contractor at the hospital, whether she would be able to pursue an interference claim against the hospital for not accommodating her. And what the court did in its analysis was it determined, looking at the text of Title VII in conjunction with the ADA and the burden analysis, that the ADA does not allow plaintiffs with disabilities to sue entities that are not their employers. The next case is Sims Madison versus Dana Commercial Manufacturing. This is a case that stands for the proposition that mere inquiries or comments about potential requirement are not necessarily enough to prove pretext, but that statements about retirement can become actionable if they involve pressure on an employee to retire or show a bias against older workers. So the facts of this case are probably not unlike situations that a number of you all have dealt with in your work. This was an individual who worked at a manufacturing company and had some disciplinary issues during the course of her employment. First, beginning in July of 2017, where she was accused of inappropriate behavior towards employees in the form of cursing or being disrespectful. After this one-day suspension, about a year later, there were complaints by other employees of similar misconduct and inappropriate behavior. During this meeting, plaintiff, the employee, indicated to the HR manager that she was only planning to work for another 5 months before she retired. And when the HR manager indicated that if something else came, if another instance like this came up, that she would be terminated or subject to further discipline, the plaintiff indicated, I'd rather just retire than deal with that. And so in light of that comment volunteered by the plaintiff, the HR manager decided to reduce the suspension to 1 day and a final written warning, which included language that the company would fire her immediately if she engaged in similar behavior. Of course, we all know where this is going. Over the next couple of months, there were more complaints. The company initially declined to fire her on the first instance of additional complaints, but after the complaints continued to mount up, the company placed her on a suspension pending an investigation of the complaints. And while plaintiff denied the claims, she did indicate that, again, she would consider retiring immediately in lieu of disciplinary action. And she offered to retire if the company would be willing to pay out her remaining vacation and union benefits. She later denied this, but HR, based on that information, approached her with an offer saying, look, we can all part ways here. They sent the offer to her and the union. There was no response, at which point, after 3 weeks, they decided that she was rejecting the offer. They completed the investigation. They found that she had violated the final written warning, and they terminated her. Subsequently, she pursued a claim for age and race discrimination. Her basis for this was that the non-discriminatory, legitimate non-discriminatory reasons of the company for terminating her was a pretext, and this was based on comments that she alleges the company made related to, her impending retirement, asking her when she was going to retire so they could prepare her paperwork. And in one instance, while the HR manager was putting up some retirement banner decorations for another employee, made a comment, this could be you. Ultimately, the court looked at the pretext argument and found that there wasn't any sufficient proof by the plaintiff to support that the reasons were pretext and not the real reasons for the termination. And this, the important takeaway from this case is that, at some point, comments can and do merge into actionable as opposed to just innocuous comments. And so some examples of what would be considered innocuous and not necessarily actionable would be, inquiry about when someone might retire, or what their plans were after they did retire, whereas something that might be actionable would be more direct. There were examples that one case where an individual said, this company is being run by white-haired old men and waiting to retire. And another indicated that he did not want to hire anybody over 50 on his staff. So we can see the differences in the types of comments that can become actionable. Next slide, please, John. And an example of a case where the comments were considered pretext, or that there could be considered pretext was Blitz over Tennessee Valley Authority. In this case, the individual pursued claims of age and disability, discrimination, and retaliation charges related to a demotion that he experienced in his employment. He had previously gone off work to deal with liver transplant that he needed. And when he returned, his supervisor made comments to him about his health and age, including things like I think your disability is slowing you down. You know, you're too old to be doing this. And the pretext arose when the plaintiff's son was hired for a training program, which the plaintiff actually taught. The company or the Tennessee Valley Authority put together an ethics committee to investigate whether that was an ethical violation for him to be teaching his son in this program and whether there was something untoward there. Ultimately, they demoted him, which was a significant reduction in his salary. The Sixth Circuit reversed and found that there were reasonable alternatives to the demotion, which likely render it more likely than not that the supervisor's, comments and animus, rather than the ethical conduct, was the basis for the demotion, and therefore the court reversed. Next slide, please. Now turning to some developments in Michigan specifically, the legislature, generally speaking, there were fewer new laws that took effect in 2021 and 2022. One of the most significant ones and recent note was in 2020 with the COVID-19 leave laws, which still remains in effect. And just as a quick reminder, this act this act prohibits an employer from taking certain actions against employees who do not report to work under certain circumstances relating to COVID-19, prohibits an employee from reporting to work under certain circumstances, and prohibits discrimination and retaliation for engaging in certain activities. Additionally, there's been some recent court activity which we'll address toward the end of the presentation, specifically as it relates to Elliott Larson interpretation and some actions that were taken by the legislature that were invalidated by the Court of Claims. Next slide, please. And so just a reminder, the COVID-19 Leave Act, PA 339 of 2020, it outlines the different COVID-19 requirements that are still in place and incorporates changing federal, state, and local health guidelines, typically requires a review of county health department requirements and CDC guidance. And as I previously stated, it prohibits employers from taking certain actions against employees who do not report to work during these periods, as well as those who oppose violations of the act or report health violations related to COVID. And turning to MIOSHA, Michigan's Occupational Safety and Health Administration, the COVID-19 rules, in 2021, they rescinded the COVID-19 emergency workplace rules and instead adopted the federal rules for healthcare employers. The MIOSHA still encourages employers to follow CDC guidance for vaccinated and unvaccinated individuals. However, it does alleviate some of the prior requirements, such as the need for a COVID-19 preparedness and response plan, daily screening, training on certain COVID-19 safety measures. But we still do need to be mindful of the need to comply with general requirement that we are responsible for maintaining a safe workplace for our employees. And with that, I'll turn it back to Laura for some additional updates on some federal cases that came down in Michigan.
Thanks, John. This case, James versus Quanta Services, Inc., as a lawyer, I love this case because we see this a lot. Basically, what happened is the plaintiff was terminated and went to the EEOC and filed a complaint. The EEOC investigated and actually issued a finding. But the issues here, the case was going to trial under Title VII of the Civil Rights Act, and both parties brought motions in limine, which, as many of you know, are motions that we bring ahead of trial to try to limit or get evidentiary rulings before you go to trial, so that you don't have to delay things or tick off the jurors with a bunch of motions that could be heard ahead of time. So in this situation, the plaintiff was claiming a hostile work environment and denial of promotion because of his race. And he brought a motion to exclude the EEOC notes, opinions, and findings from evidence. He didn't want that to go into the record in his trial. And the defendant wanted to introduce only the charge form for impeachment purposes. So they didn't care. They weren't seeking to put in the notes, opinions, or findings, but they wanted the actual complaint that the plaintiff filed. And the court held that the defendant should be allowed to use the charge of discrimination to impeach the plaintiff's testimony. And the court held that the actual, if you go to the EEOC, rather than calling it a complaint, they call it a charge. And the complaint or charge that the plaintiff filed with the EEOC did not allege that he was subject to a hostile work environment. It did not mention that he was denied a promotion for discriminatory reasons. And the only date that he identified that he was allegedly discriminated against was the date of his termination. So then once he got into the lawsuit, he came up with all these other claims. And the defendant wanted to take his actual complaint that he wrote out for the EEOC to show that he wasn't complaining of that at the time he was terminated. He just came up with it later, and thus he was less credible. And again, we see this all the time when plaintiffs, people file charges with the EEOC, they don't put a laundry list in there, and then in litigation, all of a sudden they come up with all these other things that allegedly happened to them. And so this is a great decision for employers, in my opinion. Next case is Webster versus McLaren Lapeer Regional Hospital. And there was a complicated set of facts. There were various levels of HR people involved. The plaintiff had numerous performance issues that had been addressed with her. She was terminated following her involvement in an investigation, and the defendant's position was the investigation had nothing to do with it, but she alleged it was in her termination was in retaliation for participating in this investigation. So she alleged retaliation under Title VII and Elliott Larson. And the underlying facts were, there were a lot of them, but basically another employee of McLaren Lapierre went to her as an HR person and complained that the regional director of HR had sexually harassed this employee. So the plaintiff in this case took that complaint and took it to one of her supervisors, who in turn then conducted an investigation. So basically the plaintiff was the conduit for an employee's complaint to someone higher in HR than her, and the complaint was against the head of HR. The court granted summary judgment to the employer based on the employee's failure to engage in protected activity under the opposition clause or participation clause of Title VII and Elliott-Larsen Civil Rights Act. So what are the opposition clause and participation clause? Title VII, this was a federal court case, so it was decided under Title VII, but Title VII and Elliott-Larsen have very similar language. And they both say that it's an unlawful practice for an employer to discriminate against any of their employees because the employee has opposed any practice that is unlawful under this act, or because the employee made a charge, testified, assisted, participated, or in any way was part of an investigation. And in this situation, she did not actually investigate, so she didn't take protected activity. She only took the report. It was for an internal investigation, not an EEOC pending charge, and therefore no protected activity, no violation of Title VII or Elliott-Larsen. So that's another good case for the employers. Next slide, Walls versus Graphic Packaging Corporation. This is a Western District case. The employee had been granted intermittent leave for irritable bowel syndrome, and part of the intermittent leave requirements were that if he had foreseeable medical treatment coming up, he was supposed to give 30 days notice, but in any event had to give notice ahead of time. He came in one day, got a message from his doctor's office that he skipped an appointment and they were going to drop him as a patient unless he came in to sign paperwork. So he panicked, told his supervisor that he had to go to the doctor's office that day to fill out paperwork, not because he was sick, not anything to do other than to fill out paperwork. The supervisor repeatedly told him through the day that she was unable to find anyone to fill his shift and he couldn't leave. This was a manufacturing job, which is very difficult to let people just skip out in the middle of the day if someone can't take your role. So he left. He ultimately was terminated for abandoning his job without permission. He filed suit alleging that the company violated Elliott-Larsen, the Michigan Persons with Disabilities Civil Rights Act, and public policy in general. His claims were retaliation and discrimination under the Persons with Disabilities Civil Rights Act, and the court held that he had to show pretext, and then the employer showed that there was a legitimate non-discriminatory business reason, i.e. he abandoned his job and he didn't give sufficient notice of planned medical treatment. They said that the employee could not establish a prima facie case of retaliation or that the legitimate non-discriminatory reason was pretextual, and so the dismissal was affirmed. They held that he did not engage in a protected activity, which protected activities under the Act are either opposing a violation of the Disability Civil Rights Act or making a complaint under the Persons with Disabilities Civil Rights Act. He didn't do any of that. He just skipped out, didn't have a good reason, and so the employer did not violate any of these acts, when they discharged him. McNeil Marks versus MidMichigan Medical Center. Many of you probably have heard of this case in prior presentations, even though I said we haven't even done an update on the law in a long time. This case has bounced from Circuit Court, Court of Appeals, Supreme Court, Court of Appeals, Circuit Court, so many times it's ridiculous. It with the first Court of Appeals opinion, I believe, was in 2016. So it's been around forever, and it's got some important issues under the Whistleblower Protection Act. And that's the reason it keeps going up and down. And from an attorney standpoint, we found the original Court of Appeals decision extremely disturbing. This Court of Appeals panel held that the trial court initial decision was correct, and the Court of Appeals opinion, the earlier Court of Appeals opinion, was erroneous, which from our standpoint is a good thing. So basically, the plaintiff had a PPO against somebody. She worked at a hospital. She was at work and saw the person with the PPO being wheeled down the hall in a wheelchair to surgery or something, or on a gurney. And she panicked because she thought now the person with the PPO would know what department she worked in and that it was a violation of her PPO. So she called her personal attorney, unrelated to her employment, reported that she saw this person. She thought it was a violation of a PPO, but told the attorney not to do anything about it. Unbeknownst to her or the attorney, there was another PPO out there that got served, and it created a lot of issues. She ended up being terminated, and she claimed it was a violation of the Whistleblower Protection Act because she was protected, because she informed her personal attorney that the law was violated. This court held, again, that the trial court correctly decided that the plaintiff failed to make a report under the Whistleblower Protection Act and summary disposition was proper. And they discussed that under the Whistleblower Protection Act, the person making a claim under the Whistleblower Protection Act must establish that she initiated a report, which must involve the making of a charge against or the making of a report of a known violation or suspected violation of law. And here, she didn't initiate a report. She told her attorney, who didn't report it anywhere. And the holding is good for if you have a Whistleblower Protection Act claim, the elements of reporting and who you report to are laid out pretty well in here. The court also said that an attorney who merely fits the broad definition of public body by virtue of practicing law in the profession does not suffice for making a report to a public body for Whistleblower Protection Act purposes. So if you have an attorney who's just in private practice, like this one was, and the only connection is that they're an attorney that is governed by the state bar, that's not enough. If you have an attorney who represents a municipality or other public body, that's different. That could be a report to a public body, but just reporting to an attorney in private practice is not a report under the Whistleblower Protection Act. So hopefully we won't see this case again, but I think it's actually on appeal to the Supreme Court right now. I did not double check that, but I think it is. So next time we do a legal update, we probably will hear about this one again. Next case. This one deals with arbitration again. There's a lot of movement out there to on arbitration provisions right now. I think more employers are using them and more people are challenging the employer's use of arbitration agreements. So in this one, a former employee challenged the arbitration provisions. In the employee agreement, arguing, it's actually a female, I think, she did not sign the agreement and couldn't be bound by the provision. In arbitration, the employer received an award of damages plus attorney fees and costs. The former employee challenged enforcement of the arbitration award. The court held that collateral estoppel precluded re-litigation of the issue, and the court affirmed the trial court's confirmation of an arbitration award. So if you have agreements that employees have to arbitrate, they usually contain language that the arbitrator's decision is final, and they can take it to circuit court if the if the arbitrator's decision is not complied with. So the arbitrator makes a decision, one party or the other refuses to abide by it, the other party can take it to circuit court for a judge to enforce the decision, but the circuit court can't relitigate it. And that's what happened here, basically. They said that collateral estoppel precluded relitigation of the issue. The arbitrator's decision was final. The next case involved Naylor versus Michigan State Police. The plaintiff claimed sex discrimination under Elliott Larson. It discussed prohibited conduct, the elements of a prima facie case, and the issue on appeal was whether the employee suffered an adverse employment action. And it was interesting. It's an interesting case because the plaintiff received a promotion to uniform sergeant, but she wanted detective sergeant, and she kept applying for detective sergeant positions, and she didn't get it. And she agreed, everybody agreed, that uniform sergeant and detective sergeant were lateral moves. So basically, the employer's position was, it doesn't matter which sergeant position you had a sergeant position. If you moved to the other one, it would have been a lateral move, so no adverse employment decision. And the court looked at the actual facts, and the turning point in the decision was the job descriptions. The descriptions or the positions held the same rank, same title, identical pay, benefits, retirement access. But the court, in looking at the job descriptions, found significant differences and thus held that a denial of a lateral transfer was an adverse employment action. So I think that's a significant thing for employers to consider. If you think you're moving someone into a comparable job, it's bigger than just, title, pay, benefits, etc. In this situation, the court said that the uniform sergeant position had a less distinguished title and significantly diminished material responsibilities. Basically, the uniform sergeant was more of a people manager of officers under her, while the detective sergeant went out in public, didn't wear a uniform, investigated things, interviewed witnesses, went to court. So while the benefits were the same, the actual job duties were not, and the employer lost on the basis of the actual job descriptions. So keep that in mind when you're doing your job descriptions and when you're moving people around that are unhappy with the change in position. And the last case I'm going to cover for you today is Chambers versus Catholic Charities of Shiawassee. And this again is an arbitration case. How many of those have we talked about already today? It's kind of crazy, but these are the cases that are coming down. So in this situation, some former employees brought this lawsuit alleging race-based employment discrimination and retaliation in violation of Elliott Larson. The employer brought a motion to dismiss, stating the parties entered into binding arbitration agreements. And on appeal, the case was dismissed. And on appeal, the employees argued that the trial court erred by concluding they were bound by the arbitration agreements because they were found in the employee handbook. And the court agreed, and again held, this is standing law in Michigan, but this just reinforces it, that arbitration agreements in a handbook do not form a binding contract. If you want to have arbitration agreements with your clients, they have to be completely separate from your handbook. It's not enough to put a statement in your handbook. It's not enough to put it on your acknowledgement page that they sign, that they agree to arbitration. And the reasoning is that every good handbook states this is not a contract. This is not binding. The employer can change policies whenever they want to. And so the court reasoning has always been that if the employer isn't bound by the policies, then employees aren't either. So if you're going to have arbitration agreements with your employees, make sure they're not in your handbook, but instead are a separate, completely separate written document that the employee signs off on. If you do that, they'll be upheld. And with that, I'm going to turn you back over to John.
Thanks, Laura. So I'll try to breeze through these because I know I was a bit long-winded in my last session, but this next case we think is significant because often in these employment dispute cases, including terminations or wrongful terminations, there's often a claim made for violation of public policy, that the termination was against public policy. And in this case is significant because the court has essentially bolstered that argument for the plaintiff's bar and recognized that, even if you have an at-will employee, that, there an internal complaint of a violation of the law may make a subsequent termination at least cloudy as to whether it was in violation of public policy. So just briefly, the facts in this case, the plaintiff was an IT support technician for a contractor that worked at Fiat Chrysler, and he was in that role via a staffing company. His complaint to one of his superiors was that he thought there was some asbestos insulation in one of his work areas and that it was unsafe. There was an investigation by an outside expert who determined that there was no asbestos issue. Lo and behold, a month later, Fiat Chrysler announced some business changes that ultimately resulted in some contracting of the workforce, and plaintiff was informed that a couple of his co-employees were being transferred to a different location, but that he was not. So he was told that the staffing company would continue to look for work for him, but he subsequently filed a discrimination complaint with MIOSHA, alleging that he was discriminated against, retaliated against for voicing concerns about asbestos, and subsequently the staffing company advised him that he was no longer employed by their company, and that and so he then turns around and sues both Chrysler and the staffing company, alleging that they terminated, that his employment was terminated because he was about to report their violations of the law as it relates to asbestos and violations of MIOSHA. On the lower court granted the motion to dismiss the case. The case was appealed. The Court of Appeals recognized that while the prevailing law in Michigan is that the employment relationship is terminable at the will of either party, there is an exception to at-will employment based on the grounds that discharging an employee is so contrary to public policy as to be actionable. And the exceptions or the instances where a discharge has been determined to be contrary to public policy are based on either the employee's exercise of a right guaranteed by the law, the employee's exercise of a duty required by the law, or in this instance, on the employee's refusal to violate the law, which I think in his mind was to notify of violations to MIOSHA. The Court of Appeals found that argument was without merit. There was no case law extending the public policy exception to internal reporting of violations or alleged violations of the law. Additionally, there was no issue of fact whether, either Chrysler downsized plaintiff's position or the staffing company terminated him in retaliation for his refusal to violate the law, or any evidence that either of those companies actually violated the law. The Supreme Court held that the Court of Appeals decision was an error, basically that the public policy exception does not extend to discharges in retaliation for internal reporting of alleged violations of the law. The Supreme Court held that was an error, that holding. The court recognized that the claims that were being asserted by that individual were based on two of the exceptions. One, that it was, that he was exercising a right conferred by the Occupational Safety and Health Act, and that he refused to work in those conditions. Ultimately, the court noted that the court stated as a basis for its reasoning, we see no reason why limiting public policy claims to external reports would serve the welfare of the people of Michigan, especially where the Whistleblower Protection Act might otherwise preempt claims that involve reports to public bodies. And so essentially they said if the purpose of this protection is, in furtherance of public policy is to protect the welfare of the people of Michigan, then it makes no sense that we would only limit that to external reports, and that internal reports should be afforded that deference as well. And so this case establishes that, internal reports of violations or suspected violations or communications that an individual may be planning to make a complaint to MIOSHA or any other agency related to a violation, that may trigger this public policy exception, and therefore, it would be wise to consider those ramifications before making any employment decisions. I'll try to get through these next ones quickly. I didn't do a very good job with that last one, but another case that I would imagine most people are aware of is Rauch World versus Michigan Department of Civil Rights. This was a couple of cases combined, which essentially challenged whether the Elliott Larson Civil Rights Act protections against sex-based discrimination extended to gender identity or sexual orientation. And the Supreme Court took this up and focused its analysis on the interpretation of the word sex in the Elliott Larson Civil Rights Act. The court concluded that discrimination on the basis of sexual orientation necessarily involves discrimination because of sex in violation of the Elliott Larson Act. Specifically, they noted that to deny an individual the full and equal enjoyment of the goods, services, facilities, privileges, advantages, or accommodations on the basis of that individual's sexual orientation is action that is dependent upon the individual's sex. Furthermore, sexual orientation is inextricably bound up with sex because a person's sexual orientation is generally determined by reference to their own sex. And so, in other words, if it were not for the sex of these individuals or the fact that in the uprooted electrolysis companion case that individual was transgender, neither of these companies would have discriminated but for that individual's sex. And so the court held that Elliott-Larsen extends to that, and therefore it is prohibited to discriminate or harass or retaliate against an individual based on their sexual orientation. Next slide, please. And this next one we see may have some ripple effects depending on how I should say some significant waves depending on how the appeal or appeal process plays out. This is the case of Mothering Justice versus Dana Nessel in the state of Michigan. This involves the challenge to going back to September of 2018, there were a couple of ballot initiatives that received enough support to be put on the ballot. And the legislature, in anticipation of that, passed some initiatives that were then amended to ultimately weaken the effect of those initiatives. And what's at issue here are, one is it was the Paid Medical Leave Act, and the other was essentially raising the minimum wage and getting rid of the tipped wage. I guess the tipped wage rates so that they would be increased to a certain minimum wage. And what the Court of Claims recently did was that it invalidated the legislature's amendment, finding that it was unconstitutional to essentially pass legislation and then amend it in the same lame duck session before the matters could be put on the ballot for voting as originally drafted. And so what we see with this is that there could be some significant ramifications for employers as it relates to paid leave, as well as minimum hourly wage rates, which we can and probably will address in the future. So please be aware of those changes. Currently, the ruling is stayed until at least February of 2023, but that could be extended depending on the briefing in the courts. Next slide, please. Lastly, we're seeing some trends with the EEOC. As with everything, the COVID pandemic, dramatically reduced the investigatory activity with limiting, that activity to remote discussions and Zoom calls. However, we're seeing that there's now, a backlog of cases that are being ramped back up, as well as the hiring of new investigators. There's some discussions that the EEOC is going to be more aggressive in the future with their investigations. And recently, what we've seen is that there's been an emphasis on disability rights and medical leave cases, which, we are currently defending investigations on and dealing with charges of discrimination, which we're responding to on behalf of employers. So in light of, COVID-19, long COVID and the effects that we're seeing from that, as well as the upward trend in medical leave laws, just be aware that, charges of discrimination not only are on the rise, but strict investigation and scrutiny by the EEOC is also trending. And I think this just kind of dovetails with that as well. Be cognizant, as I mentioned, of medical leave issues. What we're seeing, especially with COVID-19, is that there's more requests for intermittent leave to deal with certain medical conditions related to COVID. There's more requests for leave or accommodations and more demands for remote work. A couple of hot topics that I think most employers are likely experiencing or will experience are, requests for remote work as an accommodation, and then also requests for unpaid leave if an employee has either exhausted any state or federally protected leave that they're entitled to, but still are dealing with medical issues, whether related to COVID or not. The EEOC is really focusing on, unpaid leave as an accommodation. So there's that interplay between, the FMLA, what you're entitled to, and protected, protected leave is afforded to you, and then also, whether leave under the ADA would be considered a reasonable accommodation. And so, with any of those issues, they're very nuanced and very complicated. Please don't hesitate to reach out, and we'll be happy to guide you. So with that, just some closing thoughts. We continue to see expansion of workers' rights. Again, keep an eye on the Paid Medical Leave Act and the minimum wage provisions. Time will only tell how those will be resolved. And pay close attention to requests for leave, accommodation, and other health-related work entitlements or requests, because those we're seeing an uptick in, and we think that will only continue. And then lastly, as Laura addressed earlier with arbitration, make sure that you review your handbooks and any agreements, regarding binding arbitration for any employment disputes, and as well as, the location of those agreements, if you do want to enforce those against your employees. And again, we're always here to help. So thank you very much for your time. I'm sorry we're a little long-winded, but a lot of information to cover, and we appreciate your attention.
Well, thanks, John. Thanks, Laura. Great information. Kind of warned everybody up front it was going to be quite a whirlwind of info, so you didn't disappoint on that front. Time has come for Q&A. I did suggest that people enter questions throughout the program. There was one person who wanted a point of clarification from a slide earlier in the program regarding COVID preparedness and response plans. It was heard that it's no longer needed to have a COVID preparedness or response plan, and if that's correct, where can we find more information about that if they're no longer needed? Was that heard correctly? I don't know who wants to take that one.
Sorry, I couldn't get my mic on. You can find it on the MIOSHA site. Basically, all OSHA adopted the regulation, and then it doesn't apply to Michigan because we have MIOSHA. So OSHA does a Me Too. The OSHA regulations expired, and I don't think they were going to come out with a final rule, but they never did. And so Michigan's adoption of it, I believe, would expire with OSHA's rule expiring. I did not look at this. I didn't do that slide, I'm sorry, but I think that if you want a direct answer on that question, if you went to the MIOSHA website, it would tell you that.
Perfect. Okay, thanks. One other question. Oh, John, go ahead. Sorry.
I'm sorry. I was trying to pull it up. I couldn't locate it in this brief time, but I'd be happy to point anyone in the right direction if you want to email me or Laura or John, and they'll get that info to us, and we can provide that to you.
Okay, great. I know we talked about this next question. If paid medical leave reverts back to the ballot language that was submitted, what's the impact on employers?
Well, the immediate impact will be currently the Paid Medical Leave Act only applies to employers of 50 or more. If the original language comes into play, it applies to employers of 1 or more, and the amount of time is significant. If you're a small employer, it was defined as 10 or fewer employees. You would have to allow employees to accrue 1 hour for every 30 hours worked, up to 40 paid hours in a year, plus give your employees another 32 unpaid hours a year for a total of 72 hours off under the Act. And then if you're a large employer, which currently is defined as 50, under the original language, it's anybody over 10 employees. Same rules apply, but you have to give them 72 hours of paid leave. So the only concession for a small employer is 40 hours paid leave, 32 unpaid. A large employer of 10 or more, it'd be 72 hours of paid leave. So that's a pretty big deal. Again, we don't know what's going to happen down the line. There'll be appeals, and it's on hold currently, but keep that, in mind when you're doing your policies.
Okay, I don't see any other questions. Well, if there's one related point here about if the minimum wage reverts back to the ballot provision as well. This is another ballot question. Same question, I guess. How will employers be impacted if the minimum wage reverts back to what was submitted for the ballot provision?
I think it increases the minimum wage more quickly than the act that was passed by the legislature, but very significantly, it eliminates the tip wage. So right now, tipped employees, I think it's like $365 or something that they get plus tips. Under this act as proposed, their minimum wage for tipped employees would go to the same minimum wage for other employees. So it would significantly impact employees in the hospitality industry and other industries where the majority of their pay comes from tips. The employer, they'd still get any tips that they get, but they also would get, a $10 or $12 an hour raise in most cases immediately. So should that happen, if you're in the hospitality industry, that's something you need to plan for.
Great. One final question came in because we are at our time. It's regarding abortion benefits, health benefits. What are you advising, if anything, regarding abortion benefits, or should we just wait and see?
Well, I think it's a personal decision at a corporate level, and I don't know what the healthcare plans are doing with it right now. I guess it's a wait and see because there's so much out there to wrap your arms around, and I don't think it's settled, particularly in Michigan.
Great. I don't see any other questions. We are up against our time, so I'm going to run through some final thoughts. Sorry to speed this along, but I want to be cognizant of everyone's time. So just as we wrap up here, as we conclude, you'll receive a pop-up survey for the webinar today. Please do what you can to answer that. We really appreciate your feedback, especially when you give us ideas for future webinars and seminars. We also want to remind you that the CE credit certificates will be emailed out. Hopefully, within a couple days max. And if you don't need them, you can just disregard those. But you should get one for 1.25 credit hours for each of these certifications. The event page, just as a reminder, this recording will be out there hopefully later today, if not tomorrow. So if you need to listen to any portion of this again, that's where you do it on our event page. There will be a link. Instead of where click here to register, it will say click here for recording. So check that out and feel free to pass it along to your colleagues. Lastly, I'm going to do a plug about our Sophisticated Employer blog. If you have not been to our website, please check out our Sophisticated Employer blog. Laura, John, and a number of our other folks in the employment group do a great job of talking about some of these issues in real time in a more extended format. So check that out. You can also submit your email address to subscribe, and alerts will be sent to you as updates are made to the blog. So our Sophisticated Employer blog. On behalf of John, Laura, all of their colleagues here at Plunkett, Cooney, and myself, we did get to the finish line as promised. So with that, we are going to conclude today's webinar. And thank you once again for being with us. And hopefully we will see you down the road at our next update. Take care and have a great rest of the day.
Thanks, everyone.